Hello everybody. So in today's lecture, we'll again discuss what are the important questions which are asked in judicial exam interview. So in the past also, in many lectures we have discussed questions which are frequently asked. Today also, we'll discuss some questions which are very important and which are generally, frequently, they are asked in interview. So we'll be discussing questions from Criminal Procedure Code. In some lecture, we'll be discussing questions which are asked from CPC. In some lectures, we'll be discussing questions which are asked from IPC. In some lecture, we'll be discussing questions which are asked from Limitation Act. So all these questions which are very important, we'll be discussing in different lectures, and we'll try to summarize these questions which are very important from a judicial point of view. So in today's lecture, we'll be taking a few questions which are frequently asked from CRPC in judicial exam interview. The first question that we'll take up is that now under section 200 of CRPC, we have this examination of complainant, and under section 203 we have this dismissal of complaint. Now a question is asked in the interview on what ground complaint can be dismissed. Now if you read section 203 of Criminal Procedure Code, you will come to know that once magistrate has examined complainant under section 200, once witnesses have been examined, once reports have been seen by the magistrate, once investigation report has been seen by the magistrate, and if he finds that there is no prima facie case, or there is no enough evidence, there is no sufficient material to proceed against the accused, then under section 203 of Criminal Procedure Code, complaint can be dismissed. So if you get a question, when complaint will be dismissed under section 203 Criminal Procedure Code, you will answer that after examining complainant, after examining witnesses, after going through investigation report, if the magistrate is of the opinion that there is no sufficient material to proceed against the accused, then under section 203 of Criminal Procedure Code, that complaint can be dismissed. So this is a simple answer for the question whether complaint can be dismissed under section 203 of CRPC or not. Now the next question that we will take up is that once complaint has been lodged with the magistrate, whether it can be withdrawn or not, and if it can be withdrawn, who can actually withdraw this complaint? Yes, once a complaint has been lodged with the magistrate, it can be withdrawn. And who can withdraw the complaint? The concerned complaint can be withdrawn by the complainant itself. So the simple answer for this question is that complainant can withdraw the complaint if he so desires. Now, next question. Whether magistrate can convict an accused person under section 241 Criminal Procedure Code without recording any evidence, when can he do so? So generally, we have the evidence on behalf of prosecution, we have evidence on behalf of defense, and once evidence has been adduced on behalf of both the parties, arguments take place on behalf of both the parties, and after that, this judgment is there either of acquittal or conviction. Now a question arises, without hearing the defense, can the magistrate, it's a very important question, can the magistrate convict the person? So this question, it sounds very strange, but the answer is, all of you know the answer for this question. The answer is very simple. If the accused is pleading guilty, yes, he can be convicted even without hearing the defense in this regard. So if you get a question, can a magistrate convict a person under section 241 of CRPC? Answer is yes, he can be convicted provided he pleads guilty. So if the concerned accused person, if he pleads guilty, he can be convicted under section 241 of CRPC. Now the next question is that who can conduct trial before court of session on behalf of prosecution? Answer is very simple. It is public prosecutor who actually conduct cases on behalf of prosecution in the court of law. And when it comes to appointment of public prosecutor, you must refer to section 24 of Criminal Procedure Code, where you have elaborate provisions with regards to appointment of public prosecutor, who can be appointed public prosecutor, for how many years he must have practiced, who can be appointed a special public prosecutor. All these details you find in section 24 of CRPC. So if you get a question, who actually conduct cases on behalf of prosecution in the court of law? Answer is public prosecutor. Now, next question. Next question is very, very important. which magistrate should pass an order to remove nuisance? So you have this district magistrate, he can pass order to remove nuisance. You have this subdivisional magistrate, he can also pass order to remove nuisance, and any other magistrate who has been authorized by state government, he can also order to remove this nuisance. Now sometimes you get this question, name the authorities before whom affidavits may be shown. So who are the authorities before whom affidavit may be shown? So answer is very simple. Before any judge, affidavit can be shown. Before any judicial magistrate, affidavit can be shown. Before any executive magistrate, affidavit can be shown. Before any oath commissioner, this affidavit can be shown. And before any notary public, this affidavit can be shown. So if you get a question, before whom these affidavits may be shown, so these are the authorities: judge, magistrate, executive magistrate. Then you have this, what is known as oath commissioner and notary public. Now, next question. A marriage again during the lifetime of his wife, A is prosecuted. Can the offense be compounded? So, you know, in India, bigamous marriage is prohibited. So, whoever goes for bigamous marriage, that person will be liable. But if somebody goes for bigamous marriage, the question is whether this kind of offense can be compounded or not. Yeah, this kind of offense can be compounded. So, with the permission of the court, A's wife is competent to compound the aforesaid offense. So, with the permission of the court, in case of bigamous marriage, the offense can be compounded. In India, bigamous marriage is an offense. When we refer to section 494 of IPC, it says that whoever marries during the lifetime of his husband or the wife, in that case it amounts to bigamous marriage. And when it is bigamous marriage, whether this offense can be compounded or not, yes, this offense can be compounded with the permission of the court. If you read section 320 of CRPC, you'll come to know that some offenses can be compounded with the permission of the court, and some offenses can be compounded even without permission of the court. We have two categories of compoundable offense which are mentioned in section 320 of CRPC. So bigamous marriage can be compounded, and this is very much allowed. Now next question. Very, very important question. Now, whether a person can be ordered to pay maintenance to an adult son. So, whether adult son can be maintained by the parents and things like that. Now, if you study section 125 of CRPC, wife can claim maintenance from a husband, parents can claim maintenance from their children, and minor children can claim maintenance from their parents. Now, when these children are becoming 18 plus, parents are not obliged to maintain them. But in certain conditions, even if the children are 18 plus, they can be maintained. So, when a son has become adult, whether he is entitled for maintenance by his parents, answer is no, but under certain circumstances, even adult son can claim maintenance from their parents. What is that situation? If that adult son is, if that adult son is mentally abnormal or physically abnormal, in that case, they can demand maintenance from their parents, otherwise not. If you read section 125, if children have become 18 plus, their parents are not obliged to maintain them. Of course, 18 plus unmarried daughters, they have to be maintained by the parents. But 18 plus adult son, if he is physically abnormal, if he is mentally abnormal, then maintenance can be demanded from the parents. This is very, very important question. Now, next question. Whether an application in writing made by an accused person, whether on an application in writing made by an accused person, he can be tried for more than 3 offenses at one trial. Now this question is that if a person has committed offense on 3 different occasions, and offense are of same type, same nature, and he has committed this offense of same nature on 3 different occasions in a span of 12 months. So the question is whether all these 3 offenses of the same nature committed in a span of 12 months, can it be tried together or not? Yes, the accused can give an application to the concerned magistrate, and there can be a request, sir, please try all these 3 offenses of the same nature which have been committed in a span of 12 months. It can be tried together. We have the relevant provisions in section 219 and 220 of CRPC. All these offenses can be tried together. Absolutely no problem. But offense should be of same nature, and it should have happened in a span of 12 months if these two conditions are fulfilled, then offense of that nature can be tried together. Now next question. Whether court can take cognizance of an offense even after expiry of period of limitation, if so, under what circumstances? Right from section 467 onwards, we have limitation for taking cognizance of the offense. Now if it is fine, 6 months. If it is punishable up to 1 year, limitation period is 1 year. If it is punishable for more than 1 year, up to 3 years, the limitation period is 3 years. So a question arises, if limitation period is over, can those offences be accepted by court of law? Answer is no. Once limitation period is over, case will not accepted by the court of law. But if the concerned person gives proper explanation for delay in lodging case and all, then the same can be condoned and it can be accepted in the court of law. So the simple answer for this question, that even after expiry of the period, whether case can be accepted or not, answer is no, but it can be accepted if proper explanation is given in this regard. And if the court finds that the reason advanced by the concerned litigant is very genuine, in that case delay will be condoned and the case will be accepted for hearing in the court of law. This is very, very important. Then what do you mean by investigation? So we have 3 words: investigation, inquiry and trial. Investigation is always by the police for the purpose of collecting the evidence. Inquiry is always by the magistrate or the court to find out the truth of the matter. And trial is always by the court to find out whether a person is innocent or he is guilty. So investigation is always by the police for the purpose of collecting the evidence. And after investigation, when the works are complete, under section 173 subsection 2, charge sheet is filed in the court of law. So investigation is basically for the collection of evidence, and this is a very important task on the part of the police to be performed in an honest and fair manner. Now, next question. Can offense of cheating punishable under section 417 IPC be compounded? If yes, under what circumstances? Now the person cheated with the permission of the court may compound the offense. Yes. If an offense has been committed under section 417 of this thing, IPC or whatever it may be, the same can be compounded with the permission of the court, and the concerned person, the one who has been cheated, he can actually request the court for compounding of the offense. This is very much allowed. Now, what is the maximum amount of monthly allowance for maintenance which a criminal court can grant? Now, this is a very important question which are frequently asked in the interview. What amount of maintenance can be allowed by the court, or what amount of maintenance can be claimed from the court of law? Now the answer for this simple question is that whatever it deems fit, whatever it deems necessary, whatever court feels is necessary, that much monthly allowance can be allowed by the court. Earlier the system was that sum of rupees 500 can be allowed as monthly allowance, but the same has been removed, and now it is a discretion of the magistrate. Whatever he thinks fit, he can go ahead and grant what is known as monthly allowance. So right now it is at the discretion of the magistrate. He will see the situation, he will gauge the situation, he will see pros and cons of the story, and keeping that in mind, he can actually allow monthly maintenance depending upon the situation of the case. Now, next question. Who can investigate cognizable offense? So it is the police, it is the officer in charge of the concerned police station who can actually investigate cognizable offense. And as far as non-cognizable offense is concerned, unless there is direction from the magistrate, police officer doesn't have power to investigate what is known as non-cognizable offense. So when it comes to investigation, FIR is lodged under section 154, 155, investigation of non-cognizable offense, 156, investigation of cognizable offense. As far as investigation of cognizable offense is concerned, the same can be started by the police. As far as investigation of non-cognizable offense is concerned, unless there is direction from the magistrate, the same cannot be investigated. So if you get a question, who can actually investigate cognizable offense? Answer is officer in charge of police station can investigate cognizable offense. Now, when is an appeal not abated on the ground of death of accused? So when a person dies, an appeal is pending. Now, if you want that appeal to continue, what is the procedure for that? The answer is very simple. If you read section 394 of Criminal Procedure Code, you will come to know relatives of the person who is dead, they can actually make an application to the concerned court and they can request the court to give them permission to continue with that appeal. So if a person dies, the case doesn't abate. In case of appeal, the relative of the person, they can make an application to the concerned court. They can request the court to give them permission to continue that appeal. So in that case, that matter will go ahead and absolutely there is no problem. Now, the last question that we will discuss in this series is that what are the grounds on the basis of which such warrant may be issued? So you have the provision in CRPC 93, 94, 95 and 97, such warrant is issued. So such warrant can be issued for various purposes, for production of some documents, for recovery of what is known as stolen property, for recovery of forged documents, for seizing some publications, and where a person is wrongfully confined, such warrant can be issued to get that person released from that captivity and things like that. So for all these purposes, such warrant can be issued under relevant sections of CRPC. So these are some of the questions which are frequently asked in the examination. I hope I have answered all these questions very thoroughly. Now in our next lecture, we'll take a few more questions from CRPC and we'll discuss what are the more important questions which can be asked in judicial exam interview and what could be very good answers for those questions. Thank you so much.